What is the first thing that comes to mind when I bring up copyright law?
Books.
Probably lawsuits.
Plagiarism.
Patent.
Is there copyrights on my tweets?
Why does it exist?
That the copyright laws are there so that the artist gets all credit for their work.
For example, you're not supposed to use certain songs because you'll get in trouble for it, but the people still do it.
So don't download this song.
When you open up a book and you look to see what year it was written.
The C logo.
Yeah, that's a copyright.
Using other people's materials without their permission.
I think it's a broken system that has been started to, instead of protecting the pieces, it's protecting corporations. That's what I think of when I think of copyright.
Welcome to The Extra Dimension. This episode is on the topic of copyright law, featuring Brian Mitchell and Ian R. Buck. Find the show notes for this episode of The Extra Dimension at thenexus.tv/TED20. All right, so as we heard just a moment ago in that intro, there are a lot of different understandings of copyright law, some misconceptions, different opinions even on what it should be and you know what it currently is. So this episode hopefully will be a nice primer into the subject for just about anybody, whether you have had some experience with copyright law before, or if you don't understand what it is at all. So, shall we get right into it, Brian?
We shall.
All right. So copyright, right off the bat, is a type of intellectual property, which means intellectual property is basically like anything that applies to stuff that we make with our minds.
It's more, creative works.
Ideas. Inventions.
Yeah, brand. So, notable things, songs.
Mm-hmm.
Yeah, anything you make with your mind. That's it. That's a good way to put it.
And so, yeah, we separate intellectual property into a few different categories, and copyright is one of those categories. So copyright specifically covers all of those creative works. But yeah, so it's separate from like patents, which are for inventions and designs, and it's separate from trademark, which is for branding. And copyright, because it's for creative works, it actually works a little bit differently than like patents do, because for example, patents, you have to go and apply for a patent, right? And have it filed at like a government office in order for you to hold a patent.
And in every government that you wish for it to be patented under.
Right, yeah, because if you want it to be patented both here and like in the European Union, yeah, you got to go to both of them. Whereas with copyright, as soon as you create something, you automatically have the copyright for that work, as long as it's something that you came up with on your own.
Yeah, it's assumed that you own your own creative work.
Mm-hmm. Now, copyright has not that long of a history, actually, when it comes to like big philosophical ideas. So in 1709, Britain was the first time that we had any legislation that covered like creative works, and this was the Statute of Anne, and it was created in response to this growing tendency of people who owned printing presses to just like take existing books and make copies of them and just sell them without the author's permission, because who is going to stop them, right?
That sounds like a huge Wild West, because I mean, printing presses were the first time that you could really mass produce something. And so before, it would take a lot for someone to write it out, so you can't have as much scale. So I guess the ability to copy things is what kind of spawned it, hence the name copyright.
Yep. And we recently went through kind of a similar transition, and we'll get into a lot of that, but with the digital age now, it's much, much easier to make copies even than it was before with printing presses. So we're like, copyright law is kind of going through a shift as we speak, for like to mold with the new technologies that have made new things possible. So after Britain came up with their copyright law, many other countries started to put their own copyright laws in place. But for the most part, they didn't recognize copyrights from other countries. So back then, it was kind of similar to how patents are, right? Where you couldn't really assume that your copyright would be honored in other countries. However, over the course of the years, we have had a lot of international agreements regarding copyright have been signed, and that started with the Berne Convention in 1886. And that's actually the one that still kind of forms the basis of most of our copyright law today. And by now, it's pretty much universal. So as soon as you have a copyright in any country, it's going to apply in almost every country in the world, which is pretty crazy because I can't think of any other pieces of law that have that such far-reaching implications.
Yeah, like the human rights and things are kind of, we see them as assumed, but you have to be part of the United Nations to really see that in a legal way.
Mm-hmm. Yeah. So I guess the two things that are the most important to human society that we all agree on are human rights and whether or not musicians should be compensated for their work. Oh man, priorities, right?
Yes.
Now copyright also differs from like patents and things in kind of one other big area, and that's how long it lasts. So for patents, they usually only last for about 20 years after they're filed. For copyrights, in most countries, they last for the life of the author and then 50 to 100 years after that. Which is a really fascinating clause, and probably one of
Disney.
One of the most controversial ones, definitely when it comes to copyright. And I can understand like kind of the basis of that reasoning, right? That if an author has like written a book and they've got a family, right, and then the author dies, they want their family to still be able to get the benefits economically of their work, right? Because if you've got some business person who dies, they their family inherits all of the business that they owned, right? So it kind of makes sense for copyright to work sort of the same way for a little while.
And I think didn't it, at least in the U.S., it started out being life plus 7 years, and they doubled that to 14, and they went to like 20 and 30.
Yeah.
And so it kind of kept getting longer as a lot of these early copyrights were about to expire. They'd say, let's make it a little longer.
Mm-hmm. So you kind of got to wonder, like, how much influence those companies had who owned the copyrights for those things on the law being extended.
I think quite a lot. I mean, I think, when I hear about public domain, I think very legally things that are put out explicitly in the public domain, or, books from the 1800s, because there's not a lot. There are some, but there isn't a huge amount of things that are, fairly modern that are in the public domain. A lot of them are, I think the Happy Birthday song, the lyrics have one copyright, the tune has another, and one of them entered public domain pretty recently, but the other one didn't.
Right.
And so some company has been charging royalties to use for all this time.
Mm-hmm. And so we'll get into exactly what like royalties are and what different usage cases apply to things. Should be a good time. So we mentioned that a lot of times it's like corporations that end up owning the copyrights for things, which is not like the assumed default. So as soon as you make something, right, you, the individual author, own the copyright for that work. The exception being if this is work for hire. So, Brian, any like code that you write for work, that belongs to the company that you work for, right? Which makes perfect sense because like if I'm an individual who's working on a project, like, maybe I'm making a podcast, for instance, maybe I don't have the expertise to do all of the individual parts. So I'm going to hire out somebody else to make like the album art, for example. But because the sole purpose of that album art is for my show, then, it makes perfect sense for me to be the copyright holder for that thing.
Yeah, it's still going towards the original creator of it all.
Yeah.
The organizer.
But of course, individual people are not the only ones who hire other people to do things. In this day and age, it's almost always companies who are hiring other people, right?
Yep.
And as we all know, corporations are people too. Thank you, Citizens United.
Yes.
All right, so let's talk about some examples of the types of works that copyright usually covers. Because we mentioned that it's artistic works, but that's kind of a nebulous term, right? And so this list has actually kind of expanded as time goes on and as new types of works enter the world. So obviously they started off with like books, right? So literary written works are covered. Things like lectures, addresses, sermons, motion pictures. I don't think that those existed back in 1709.
I don't think so either. Other things like choreography, musical compositions, sound recordings, paintings, drawings, sculptures, photographs, software, more like the work of the software, not necessarily the code or the branding around it. Broadcasts, graphic designs and industrial designs, translations and adaptations are, this is quoted from the article, protected as original works without prejudice to the copyright of the original work. And collections of artist works are protected without prejudice to the original works.
So yeah, that phrase is actually a really important thing to note because, so let's take the example of like, Gabriel Garcia Marquez writes a great novel in Spanish, right? And so then they want to translate it into English so that English readers can experience it. Obviously, Gabriel Garcia Marquez still owns the copyright for the original version, but then somebody else had to translate it, right? And the translation has its own copyright, but it also still depends on the original work's copyright. So nobody can publish an English translation of 100 Years of Solitude without both the permission of the person who owns the copyright for the translation and the permission of the person who owns the copyright of the original Spanish version.
Yeah, and I think that kind of comes out because while the original content is the same, a translation can really have a difference on how someone interprets the story.
Definitely.
Between languages and things. So it's important to show that while this isn't an original creation, there's a lot of work and effort and, I guess, original adaptation that goes into it.
Mm-hmm. And then also, I was very interested to learn that like collections are covered under copyright. So
this is like an anthology or a best hits CD or something.
Yep. And even like I believe that this expands all the way to things like if I just make a playlist, right? And I own the copyright for that particular order of the songs, or like, a mixtape if we were back in the 90s. But I can't just like give that playlist with the content of the songs to somebody else without the permission of the copyright holders of all of those songs. So I could tell you, Brian, like you should listen to songs A, B, and C in that order. And then in theory, I guess you can't tell anybody else that because I still own the copyright for that, for telling you that it goes in that order. Yeah, that gets a little bit complicated.
So it's up to you how you enforce it, how much you kind of publish it and release it.
Exactly. Yep. And actually, we should probably note now that that list of like copyrightable works came from a document that I've been reading by the World Intellectual Property Organization, a branch of the UN who like helps like develop all of these treaties and everything between lots of different countries. And the really cool thing is that they released it under a Creative Commons license, and we'll be getting into Creative Commons later. But yeah, if you're interested in reading that full document, the link is in the show notes.
So in addition to these kind of copyright works, we should note that copyright does not cover ideas and information, only the ways that they are expressed or recorded. So it's kind of how you capture raw thoughts and things that come out of your mind.
Yep. Yep. So like, if you think about choreography, right? If I'm just dancing a particular set of moves that I have choreographed, it doesn't really mean anything until I have written down or recorded it in video or something like that.
You have to have it kind of documented in a physical or digital way.
Yep.
In order to kind of prove that this is in fact what you came up with.
Mm-hmm. And it's also interesting to note that copyright applies to original works, but it does not guarantee that they're unique. So if two different authors independently create very, very similar works, they both still own the copyright for their own version of it, which probably makes it a little bit harder to enforce.
Yeah, I would say so. I think in a digital age, it can kind of you can kind of see how or when someone releases something, but I think, or I can imagine there are probably many cases where this is a difficult area.
Right. And for things like, like a podcast, for example, it's rather easy to distinguish like my voice from somebody else's voice, unless it's my dad. But things like Foley artistry, right? It's pretty hard to demonstrate who it was who was making those sounds. So enforcing a copyright in that area would be almost impossible, I think. Yeah. Now, copyright covers two different categories of rights, and this is something that I did not know until I was doing the research for this episode. So the first is probably the one that we think of most often. That's the economic rights. So as a copyright holder, you have the right to derive financial reward from the use of your work by other people, and the economic rights are usually transferable to other people. So yeah, I could sell the copyright for my work to another entity, and then they have complete control over it. However, the other category is moral rights. And the moral rights refer to things like preserving and protecting the author's link with their work, and also like preserving the authenticity of the work itself, right? So attributions, would preserve the moral right of the author, and also like not misquoting things would preserve that. Mm-hmm. And moral rights are not usually transferable to other people. So I can't. Well, yeah, and so you get into like weird things like ghostwriting, right? Where one author is writing something, but another author is telling the world that they're the one who wrote it, instead of the actual author. So I guess that would be a breach of moral rights. And in some countries, moral rights last forever. So like no matter how long ago something was written, we still have to attribute it to the original author.
So I haven't seen, I didn't know about the difference between economic and moral rights. I think ghostwriting you bring up is kind of an interesting idea. I think many, songs that are big pop songs, they're not written by the single artist. They're written by a bunch of different people, and whether or not they're given attribution, I think, in a CD, you might have this song was produced with, written with, yada, yada. But mm-hmm. on, Spotify, you don't see that. And so where's the line of...
Yeah. You can usually find it if you go to like the Wikipedia article for a particular song, but but not everybody goes and reads that. Yeah. Yeah, it's like, do we have metadata slots for all of those things? I don't know. Now, there are, of course, even further breakdowns that we can go into those two areas. So there are different types of economic rights. First, there's the reproduction, distribution, rental, and importation rights. So distribution is kind of a situation that is changing in the digital age, because previously, as soon as an author sold a copy of their work, then they no longer had the right to like dictate what happens with that individual copy, right? So as soon as I go and buy a copy of a book from the bookstore, I can just give it away to somebody else if I'm done reading it, and the author can't stop me from doing that. But in a digital world, right, it's when we're working with machines whose like sole purpose is to just make copies upon copies upon copies, right? If I send a file from my computer to yours, chances are the copy on my computer and the copy on your computer are not actually the only copies that were made, right? Because it had to bounce around between probably at least one or two servers on its way to you, right? So each of them has made a copy, and who knows if they're like keeping a copy, and it gets really complicated really fast.
It depends what services we're using. If it's direct or direct, nothing see. It's just a stream
Right.
of packets. However, you could send me something that you created that you have copyright on, and I take it and say, I'm going to fill up my computer, and I make several million copies of that. Do I now have to pay you for several million copies of that, or? Or do I still have the one? And I know with games as well. You buy a game on Steam, you can't get rid of it. You have to always have access to some online server to make sure that you can use it. So DRM really comes, digital rights management comes into play here. I think will we talk about that later?
Not extensively, but yeah, digital rights management is one way of trying to control the copyrighted materials without like having to go to court, basically, is kind of the the bottom line there, right?
Yeah, and that's a whole nother topic that we can discuss in a future episode.
Definitely. Now, public performances, broadcasting, and communication rights are another section of the economic rights. So basically, like, if I wrote a play, I get to decide who can perform it live. And also, like, playing a recording of something for a large group of people, or broadcasting it, to the public, that kind of thing, that is also the right of the author to control.
So I know at the University of Minnesota Morris, where we went to school, I was in the tech crew there, and we had movie nights that was paid for by the student activities office and things, but they would pay $500-600 per movie to show it, because they have to pay extra to show it in a public space. And so that's another way that copyright holders can kind of leverage those rights, make people charge more, because more people are going to be viewing it, so they can charge more and make more off of it.
And then, of course, authors have the economic rights to translation and adaptation, so they get to choose when and where different versions of their work are going to be produced and sold. And one of the questions now in a digital age is that how does this relate to user generated content, right? Because you see, as soon as a TV show goes up, right, or an episode of a TV show, there's immediately like GIF compilations of it with maybe the same lines from the episode overlaid on it, but sometimes people put other like reaction things onto them. So they are creating new stuff with it, but like the question is to what extent are they allowed to do that before it becomes an infringement of the original copyright?
And a lot of time that falls under fair use, where you can use something if you're kind of remixing it and making your own thing basing off the original one. And that's where the idea of public domain really comes into play, because something's been out for a long enough time that the original copywriter or the original creator has had enough time to make what they can off of it. And now it's in the domain of the public to further adapt and base new things off of that.
Yep. Although you can probably assume that a TV show that is an episode that is currently airing, and there are already like GIF sets of it online, that's not in public domain quite yet.
No, not quite. But I think a lot of the times the copyright holders can choose to enforce or not enforce different things.
Yep, definitely. And I believe so one of the quirks of trademark law, which again is separate from copyright law, is that in order for a trademark to still be valid, the holder of the trademark has to demonstrate that they have done everything that they can to defend that trademark, right? And I'm pretty sure that does not apply to copyright. You can choose whether to enforce copyright selectively in different cases.
Yeah, well, and with copyright, you can say, "Yeah, I give you permission," and then it's done.
Yep.
It can be verbal. Since it's not you don't have to submit something to have a copyright. it's a little less formal.
Mm-hmm. Yep. Let's talk about transferring copyright, because there's several different methods of doing that. So first is assignment, which is a direct transfer of copyright. So the original right holder gives up their copyright in order to give it to somebody else. Licensing is the form of transfer that is most often seen. So the copyright holder retains the copyright, but allows a third party to use the work in certain ways. So, whenever you hear like a pop song at a sports event, right, they have licensed the use of that song at that sports event. But that doesn't mean that the person who owns the arena can go and use that song again in a different context, right? Because licenses usually have a very specific use that they allow and a specific like time frame that they allow it to be used in.
And I think with music, a lot of the time, huge events they're going to pay to license, because the record labels or artists are going to know about that event and say, okay, hold on, am I getting any license fees for this? Whereas smaller things like, I'll use Morris again as an example, house music before some show or during the dance show, there's no license fees paid there other than the individuals purchasing those songs in the first place.
Right. Yep.
And so it's kind of how much the people want to enforce it.
I remember listening to one of like the student run radio shows on KUMM and calling in and requesting a song, and they were about to play it, and they were like, oh, hold on, we got to wait for the Spotify ad to finish before we unmute it. And I was like, are you guys for real? This is how you're doing it?
I think there is a law about radio. So if you play a song that was in the top 40 anytime in the last 10 years, you can't play it on the radio without licensing it.
Huh.
I remember hearing something about that for at least the Morris student radio.
Mm-hmm. Interesting.
Minnesota, US, I'm not sure where the limits are on that.
Next up is royalties. So this is a type of licensing where the copyright holder gets paid based on how many times the work is used. So actually, I think licensing it for a specific sporting event would be an example of royalties. But also, like in general, if a musician like signs on with a label, usually one of the clauses in their contract will be that they don't just get paid like a lump sum right away. They also get paid for how many different places license the use of that song from the label.
So things like Spotify, they're gonna pay, the record label charges a fee of who knows how much it is, like 0.5% of a cent on every stream of a specific song. Mm-hmm. And so Spotify needs to be able to pay all those royalties. So they're going to play ads for the listeners so they can pay the record labels, who then take a chunk and then in turn pay the artists.
And one thing that I've always been kind of curious about in an age where we've got all of these companies that run streaming services and everything is like, who audits that? Like what guarantees that Spotify is telling the labels the actual numbers? Because I believe that we recently had kind of a snafu where Facebook revealed that they had been over-reporting advertising numbers on their site. And so they had been overcharging advertising firms. And so it's like, well, like how would anybody have found out if Facebook had not come clean about that?
I think that, we can't see the contracts they have, but they might have mandatory audits that the third party comes in to verify a lot of these numbers. There are ways that they can, they'll only do business if we can verify things. So.
Right. Yeah. Yep. And I'm sure that the technical details of that would definitely go over my head on how exactly they can be sure that the numbers are accurate. And then lastly is collective administration of rights. So this would be an exclusive license granted to an entity that will act on the author's behalf to handle a bunch of things, including distribution, granting usage permissions, and detecting and preventing infringing of rights. So this is honestly like the biggest job that companies like music labels have is not only like finding artists that they think are worth supporting, right? So curating the industry that way, but also like doing a bunch of administrative tasks so that the musicians don't have to do it themselves.
Yeah. So that, a record label brings things like automatic distribution, but also the ability for an artist to not have to manually go around enforcing their own copyrights.
Yep. And actually, we're running into some interesting situations where, like, for example, YouTube as a platform kind of serves a lot of different purposes to the people who are uploading stuff to them, including like copyright enforcement. So if somebody else uploads a video that is similar enough to one that I have already uploaded, then YouTube will probably flag that, and then I get to choose how to deal with the situation.
Unless you say no copyright infringement intended.
Right, yeah.
No.
So yeah, let's talk about some consequences if you infringe upon my copyrights. Oh, you terrible person.
So this does depend on the region. So there are local laws or national laws of wherever area you are.
We chop off the right hand, right?
Yep.
Totally.
And then any further infringement, it's another finger or toe.
No, so for real, copyright holders may be compensated for like either the amount of profit that the infringer made by infringing, or for the estimated amount of money that the copyright holder did not receive as a result of the infringement. So I guess whichever one of those the judge goes with is kind of up to the judge.
Yeah, and a lot of DVDs and things would have a warning saying if there's copyright infringement, you'll be charged with up to $250,000. And I think that is very dependent on the case, and that's not enforced super strongly. I think, especially DVD ripping. That's another story.
Yeah. We also will likely see the infringing goods being destroyed. I think that would be kind of a first step, right? And also any tools or materials used to produce the infringing goods might be destroyed. And in very, very serious cases like piracy on a commercial scale, criminal sanctions could be brought to against the infringer. So this could take like the form of a fine or a prison sentence.
And that has happened with many large-scale peer-to-peer network listing sites and things like that.
And I'm pretty sure that, a few like individual users of those peer-to-peer sites back in the early days.
Every couple of years I'll hear about someone who has fined several tens of thousands of dollars for infringing on, I think even $10,000 for like an album of 12 songs or something.
Yeah.
Just to kind of scare people into not pirating copyrighted materials.
It's the pirates beware, and then you've got 6 people hanged out there in the harbor, right?
Yes, exactly.
Now there are a few related rights to copyright. They don't fall exactly under copyright, but they have a lot of rights that are very similar. And this would be a category of works that these works do have artistic value, cultural value, but because they are not fixed in a like permanent medium, they can't be awarded copyright directly. So we're talking things like performers' rights. Performers have the right to prevent recording, broadcasting, or communication to the public of their live performances. Which makes perfect sense because, like, if I go to see Hamilton and I just broadcast it live via my phone, then lots and lots of other people don't have to buy tickets to go and see Hamilton, right?
While something at like a music concert, many artists encourage Instagram, Snapchat, and photos, videos of the performance being put out because it's going to spread more publicity about that work or that artist.
Yeah, especially since, like, in that case, they're competing the live performance against a recording of the live performance, and obviously there are already recordings of those songs available commercially. And so the appeal there is not the song itself, but the experience of going and seeing the artist, right? Yeah. Broadcasting organizations have the right to authorize or prohibit rebroadcasting or recording of their broadcasts. And the limitations and exceptions to these are pretty similar to with copyright. So fair use would be, cover things like if you record a broadcast just for personal use, that would be okay. But yeah, like recording a broadcast and then redistributing it, that's when we get in trouble.
In general, sharing something that you haven't explicitly gotten permission for that is copyrighted work is against the terms of use.
Mm-hmm. Yep. And so then let's get a little bit deeper into some of those fair use cases, because there's several different things that might fall under fair use. So fair use refers to any circumstances under which you can do things that normally wouldn't be allowed under copyright law. And some examples would be like if you are quoting a short piece from a work and citing it as a source, that would almost certainly be understood as fair use. If you use a work as an illustration for educational purposes, actually is we get a pretty big fair pass as teachers, because it's all for the kids, right?
All for the kids.
And also using a work for news reporting is generally considered to be all right, because the news reporting, the quality of the news reporting would be reduced substantially if they were missing an actual work that they were talking about.
It's kind of saying that if it's for the greater good of all of humanity, you can probably use it.
Yeah, that's a really good way of putting it.
Within reason.
Mm-hmm. Yep.
So fair use is the area that regional copyright laws vary the most on. So something that is considered fair use in one country may not be considered fair use in another one.
Yep. And there are a lot of different factors that are taken into account when determining the limits of fair use. So, if you're taken to court over something and you want to make the argument that what you did was fair use, these are kinds of some of the things that you would want to be demonstrating. You would want to demonstrate that the nature and purpose of the use was not nefarious. Whether or not you were using it for commercial purposes is definitely important. The nature of the work itself, the original work, the amount of the work that was used in relation to the work as a whole. So I think a really good example of that would be when in some Nexus special episodes of ours where we are covering a keynote of some sort, right? And we take audio from the keynote. A lot of times that audio will have a song in the background that the company who was doing that keynote licensed. And there's not much that we can do about the fact that it's in there. And so we can make the argument that because we were just a small part of that song made its way into our final recording, nobody's going to be listening to our entire podcast episode just to hear that one song, right?
And also it's kind of, I think movie trailers and discussions about movie trailers or movies using footage from trailers is considered under fair use, because you aren't showing the whole thing, you're using a few clips of it. So kind of like a teaser, you're showing examples of the work, you're not showing the work itself.
Yep. Yeah, and providing analysis of a work is, I think, a really big category that didn't really exist a whole lot until the digital age came around, and it was much easier to make works that, reviews and analysis type things that also incorporated parts of the original work into them. And so that's, a lot of automatic copyright systems like YouTube's flag a lot of those types of videos, and then, they have to go and dispute it, and it's a whole process. And then also, finally, the likely effective use on the potential commercial value of the work is taken into account. So if I was doing something that I claimed was fair use, but it created an incentive for people to not buy the original work, then that would that would definitely hurt my argument that it was fair use.
So I know things like song remixes are, I think I mentioned this earlier, are a big, there's a big community around remixing, and
there's entire genres formed around remixing, right?
Yeah, exactly. And I think I consider that to fall under fair use, but a lot of the YouTube or SoundCloud algorithms are going to flag those remixes as copies of the original work, even if that may not be the case. And so it becomes difficult to argue the use of fair use sometimes.
And it's even so up until recently, I always thought that, like, okay, so when you create a song, when you write a song, you own the copyright for essentially like the sheet music of it, right? But then anybody can go and like make their own cover of that song without having to pay royalties to the original person who wrote it, as long as it's clear who originally wrote the song. But reading through, these things like copyright holders being allowed to limit, adaptive works, right? And performances of their work. If it was like a screenplay or a script or something like that. That's led me to believe that actually, I think covers and that kind of thing of songs would be enforceable under copyright.
Yeah, and that can be under the area of potential commercial value to the work. I generally believe that a remix can add value to the original work because it spreads the knowledge of the original work's existence. But that might be a much different view than if it were coming from the original creator itself.
Yeah, and of course, like, different people are going to react differently to finding a remix, right? So like if you discover a remix of a thing, it might pique your interest into going and looking into the original version of that song. Whereas if I find a remix, I might not even realize that it was a remix of an original song, and so I might just stick with the remix itself and never listen to the original. So it's really hard to know what the economic effects are going to be of a derivative work on the original.
Yeah, there's a great film called Everything is a Remix.
Yes.
Yes. The version I find here does not look like it's the original.
That's ironic.
Where does that fall? I think there's a website. Everythingisremix.info. I'm not sure.
.info
anyway,
is the most trustworthy top level
it's
domain.
The first thing that came up on DuckDuckGo. We'll just mention Everything is a Remix in the show notes, and you can look for it yourself. But that is a great way of describing how fair use and public domain work can really influence new creativity.
Yep. Because it's so difficult to create something just completely out of the blue. Even like you hear interviews with creators who say like, oh yeah, I was just sitting there thinking, and then the melody came to me, and it's like, well, okay, really, they were they've heard a lot of music before in their life, and so that stuff was unconsciously contributing to their thought process and everything. So we're always standing on the shoulders of giants, right? Yeah. Which brings us nicely, actually, to our last topic of the episode, which is free content licenses. So this is the concept of like free cultural works, copyleft. They go by there's a lot of different names for it. So free cultural works are any works that are released under licenses that do not restrict others' freedom to 1. Use the content and benefit from using it. 2. Study the content and apply what is learned. 3. Make and distribute copies of that content. And 4. Change and improve the content and distribute those derivative works.
So when I hear this, I kind of think of open source, because while that source might together make a final solution that can be licensed and things, they have the source of that open, so people can see how a specific thing maybe was implemented, how something works, and they're kind of giving back to the greater good, the open world, saying, here's how we did it, you can use this to base it off. And they might have you you have to license that code or something, but they're putting it out there for use for other people.
Mm-hmm. Yeah, and software is a really interesting example of the difference between just offering something to be used for free and having it be like a proper free cultural work. Because if you don't also provide the original source code for a piece of software, then people aren't going to be able to study it and apply what's learned there as easily, right?
Yeah.
And it's also going to be very difficult to change the software and distribute, derivative works of it. So yeah. I've been thinking a lot about why the free content license phenomenon has come about. And here's kind of my conclusions on it. Basically, technology has progressed to the point where we've driven down the cost of distribution for media to essentially zero. And so because of that, the number of content creators that are out there and the number of works that are available to the public has just like exploded, right? Everybody's a content creator these days, it seems like.
I mean, like hundreds of hours are uploaded to YouTube every second or something, or dozens at least. So much.
Is all of it good? Probably not, but that's all right because there's enough of it that
it is content nonetheless.
Yep, that some of it's going to be good. And speaking of making it good, a lot of these content creators realized that their works would benefit if they could incorporate the works of others into it. So, for example, I love making podcasts. I don't know squat about making music. So if I want a nice song as the intro for my show, in a traditional model, I would have to go out and first find somebody who's good at making music, and whose music I like and I want to use in my thing, and then I have to ask them for permission, and possibly negotiate with them on like licensing fees and terms and everything. And if creating these podcasts is not my like full-time job, I probably don't have the time or resources to go and do something like that. And especially, and also if it's not my full-time job, then I'm not going to have the kind of experience, the kind of knowledge to know what are reasonable terms, what's a reasonable rate, right, for licensing this kind of thing. And so because it would benefit me to be able to use other people's works, the conclusion is that it's best if lots and lots of people share their works in such a way that other people can go and use it, remix it, redistribute it and stuff. And so you get this like big, huge movement of lots and lots of artists who are all making stuff in their own areas and releasing them so that other people can go and incorporate them into their own works.
It altogether encourages more creativity because you have a base to jump off from. Mm-hmm. So everyone isn't doing the same thing over and over.
Yep. And it's not a complete reversal of copyright, the concept of copyright, because usually even if the creators have given up all of the like economic rights that go along with copyright, the moral rights still apply, right? So if somebody else uses like a bunch of clips from this podcast, they have to link back to the original work, so that the people who listen to whatever it is, or if they like transcribe this into a written version, right? They have to link back to the original work so that people can still find you and I.
Yeah, and this kind of brings us to let's talk about Creative Commons. So this is kind of a license that is out there that you can apply to your own work. So it's meant for licensing media. So maybe a podcast or a website,
video, written work,
yeah.
All sorts of stuff.
Things that you can create. And there are different levels that this license can apply. So there's, I believe there's even CC0 where nothing is allowed. Then there's Creative Commons attribution where you can...
I think CC0 is actually the opposite. CC0 is essentially public domain. where everything
Yes.
is allowed.
Yeah, so you have CC0 where everything's allowed, CC being Creative Commons, CC attribution where you are free to use and remix it, and as long as you give attribution to the original work. CC attribution share alike, which means you are allowed to use it and remix it, but you have to share yours under a Creative Commons license as well, I think. We should look these up.
Yeah, so there's kind of 3 different like features that somebody can choose whether they want to apply it or not to their license. And so then you get like I think 6 different possible configurations of it. So you get to choose whether or not you want to allow derivative works. If you are allowing derivative works, you can choose whether or not the derivative work has to use the same license as the original. And then you can choose whether or not to allow commercial reuse of your work. Yep.
And so if you look around, a lot of things at the bottom will have CC-BY-SA-NC-ND. These are all shorthands for Creative Commons attribution, share alike, non-commercial, and no derivatives.
Yep. And fun fact, let's see, what are we in? The extra dimension? This show is released under a Creative Commons attribution license. So you can go and reuse it however you want. You can even like just take this exact sound file, host it on your own thing, and run ads against it and make money off of it as long as you are clearly linking back to our original webpage.
You wouldn't even have to tell us you're doing it. You just have to tell the people who are consuming it that you are not the original creator.
Yep. Although if you do think that we're worth like taking and doing that, I would love to hear from you because that's very flattering.
Hit us up.
Now, one of the really cool things about the Creative Commons movement is that it has reached such a large volume that there are entire websites whose sole purpose is to just serve as repositories for works that have been released under Creative Commons licenses or are in the public domain or are otherwise available for people to use and remix and redistribute. So if you are creating something and you need, some photography, you can either go on to Flickr and do a search and specify that you want Creative Commons works, or you can go on to Google Images and using the search tools specify that you want stuff that is marked for reuse. If you're doing music, there's a free music archive. For all sorts of mediums, there are different repositories. And actually, the Creative Commons website has links to other websites that host that kind of thing. So it's a great resource for people who are trying to create stuff online. One of the big questions here is that, like, if I am giving away all of my media that I'm creating for free, how can I make any money off of any of it? And that is a question that we explored back in the Extra Dimension number 8. So if you are interested in that subject, go and listen to that episode. Link in the show notes.
And I think the main way to get that is the work itself might be open for use and other people to use and consume and host themselves. But what you're really being able to make money on is the distribution and how you provide it to others.
Mm-hmm. And also sometimes like related things like if it's a medium where it makes sense to have like a live show, right? You can make your money there. You can make your money off of merchandise, stuff like that. Yeah.
Now there's one more kind of type of a free content license, and this is kind of more meant for code. So this is things that I interact with more often. So there's the big, huge, there are kind of some ideologies that go into this. One is the GPL, which is the GNU public license. And oh gosh, what is GNU?
I don't know.
GNU
but yeah, GPL stands for General Public License. Yeah.
I believe it's GNU public license, isn't it? Okay, it is the GNU General Public License. So this is created by this is kind of owned by the Free Software Foundation. What this means is the source code is online and available for all to see and to use and to inspect, but any derivative works also have to be licensed under that same license. So it's forcing, if you want to use this, you have to also release yours into the domain. And so you have groups of software that have things implemented their way because they're released with this license. And so everything is free and open, but you can't have, if you're running a commercial company and you want to use this, you would be breaking the terms of the license if you included it in your product and you did not open source the part of that product that used that code.
Essentially it's share alike. Yep.
And then you have more something like an MIT license, which is more similar to an attribution, where you have to include the license of the original code and say, yes, this is originally developed by this person, this company, and it's kind of provided as is. So this is just an attribution license. You can use it, adapt it, just provide some attribution.
Yep. And these both contribute to the kind of open source movement, which is like a really, really cool thing, because unlike other forms of media, software is a type of creation that ideally changes over time, right? As technologies progress, we update software, make improvements to it and everything. And so when a piece of software is released open source, if it becomes popular enough, and lots of people are using it and interacting with that code base, lots of people, you've got lots of eyes on it, right? People using it in a lot of different ways. And so people can encounter problems with it. And if they have the know-how, they can go and solve those problems themselves, update the code, and then contribute that new code back to the project itself. And so then the original version can incorporate that new code into itself in a future update, so that not just that one person who figured out how to solve a problem is benefiting, but the entire community is benefiting from it.
Yeah, it really pushes back the improvements towards the greater good of everyone.
Mm-hmm. Yep. And there's making money off of open source software is typically typically made in the specific implementation of that software, right? So even though like Drupal is an open source content management system, if I set up a website for a company using Drupal, that company will, likely be paying me, even though the software itself was originally free. Yeah. Goodness, yes. So copyright, I'm amazed that we got through all of what we wanted to get through on copyright in such a snappy manner.
Woohoo!
But there you go. That is your hopefully about an hour primer on copyright law and how it applies not just to consumers, right? Not just how you have to be afraid of the big bad record labels coming after you for file sharing your music, but also how it applies to people who are trying to create things in this new Wild West digital age that we live in.
Yeah, hopefully it was useful, and we can discuss further things such as DRM and other uses in later episodes.
Definitely. All right, so if you wish to contact us about any of the stuff that we mentioned, if we made some mistakes or if you have further questions, feel free to hit us up. We are The Nexus. You can find us on Twitter at The Nexus TV, or send us an email at thenexustv@gmail.com. I have been Ian R. Buck. You can find me on Twitter at Ian R. Buck, or ianrbuck.com will provide you with links to other stuff that I make.
And I am Brian Mitchell. You can find me on my website at brianm.me, or on my Twitter at brianmitchL.
The letter L. As we noted earlier in the episode, most of the information came from a document from the World Intellectual Property Organization, and also from several Wikipedia articles. Our theme music was by Kevin MacLeod. Links to all of those things in the show notes, thenexus.tv/TED20. And many, many thanks to my friends, family, coworkers, and students who put up with me sticking a microphone in their face and asking them questions about copyright law. Thanks for listening, everybody.
Have a good one.